office, and our topic that we're going to be talking about today is on gifting, taxes, and how those relate to long-term care planning. I'll touch a little bit on gifting and taxes, just more from a tax perspective, but really the focus today is on how that can impact long-term care planning, or how that really interrelates. And maybe there are some misconceptions about how they actually relate to one another. So just a quick couple of reminders before I go into the conversation. Remember that if you've ever participated in one of these before, there is a Q&A function. So if you submit the question, I can actually see it come up, and I'll try to address it as soon as I can. So it's meant to be interactive, so please feel free to do that. And then you'll receive a couple of materials from us at the end of this, one of which is our kind of how to plan for your home, or different things that people may do, little chart for long-term care planning. And then also a feedback form where it's really helpful for us to always get feedback on how to improve and topics you might be interested in and all of that. So please feel free to fill that out. It is where you can let us know if you would like to set up an initial consultation as well, if anything we talk about today is raises some concerns for you. So those initial consultations are complimentary. We set them up for about 2 hours, give or take, to try to give people enough time to go through their issues. We go pretty in depth, but again, those are complimentary, so it doesn't cost you anything to at least come in and talk to us the first time. So, all right. So to get started, when we're talking about gifting, taxes, and long-term care planning, I want to get a really big misconception out of the way first for long-term care planning, because I think in relation to like gift taxes, I think people often misunderstand how they play into one another, thinking that they are more tied potentially than they actually are. So when we're talking about gift taxes, most people are familiar with the exemption amount, or that amount you're allowed to give per year without filing a gift tax return. So it used to be $15,000 per person per year. So you could give $15,000 to everybody you knew, didn't have to file a gift tax return, is what that meant. If you went over it, you did. This year, that exemption has gone up for the first time in a while, up to $16,000 a year per person. However, again, when you go over that gift tax exemption, so if I gave $17,000 to somebody I knew, I would file a gift tax return, but it doesn't mean you actually pay taxes on what you're over that amount. You actually lower your end of life exemption, which is your estate tax exemption, by the amount you went over. So now if you've already gone over that amount, then there may be some taxes associated with that. But most people, that exemption, that lifetime exemption, if you don't have a separate state estate tax exemption, depending on, the state, and in Wisconsin, we don't. The federal exemption is about it's actually $12.06 million. So it's a great problem to have, not one that I do or that many people do these days. It's like less than 0.1%. So for a married couple, right, you'd have to have more than 24 million for that to be a concern. So that's what gift taxes are tied to, though, is if you go over that amount, you lower that exemption. Where the misconception comes in with long-term care is they think, oh, that's an exemption, meaning I can do it without consequences, including in relation to long-term care. So that gift tax exemption is the IRS rule on how that is deducted if you actually go over that amount. It has nothing to do with Medicaid planning, for example. So when we're talking about nursing home expenses and using Medicaid potentially to pay for that care at some point, if somebody needs it and they've been gifting all this money away, thinking they're within that exemption, well, Medicaid says you can gift $0 per year in theory without it being an issue. So if you gift within the state or the gift tax exemption, even though you're within that exemption for the gift tax amount, you are still creating a divestment for Medicaid potentially. So it's just, you don't want to do it relying on that exemption, thinking you're somehow getting away with it, because you're not. It is something you have to tell them about, which is a big question we get about, well, how's Medicaid going to know? Well, the penalty for lying about it is fraud. And most of us don't want to go to prison over something like that. So I think being honest is important, and you're required to for that application. So that's how they find out. Anyway, so gift tax exemption, not really related to Medicaid at all, other than that most people ask that question at some point about, well, I thought there was this amount. And unfortunately for Medicaid, there's not an exemption amount or a safe haven of, hey, you can gift this much per year to everybody and it'd be okay. So with gifting, another concern with long-term care is when you're gifting over to somebody, a lot of people engage in gifting strategies to try to get things out of their name for long-term care. And we get a lot of questions about, should I gift the home or transfer the home to my kids just by redeeding it to them? Is that the safest thing to do? I'm trying to plan for, not having to spend money down for care, or I don't want my home to be available for it or other property to be available for it. So the question is whether that's a good idea. When you are gifting assets over to somebody, again, you're still creating a divestment for long-term care. So let's say the concern is not even making it out past the 5-year look back that Medicaid has. What that means is when you apply for Medicaid, they look back 5 years from the date of application. So in theory, once you're beyond 5 years, the gift is not reportable to Medicaid and they can't ask about it. So some people make it beyond the 5 years by gifting it. And so the long-term care side of it's not an issue, but where you're not accounting for a lot of things by gifting it over to somebody is a lot of other things that can happen. So there's really 3 big scenarios that I would be worried about with transferring the home over to the kids. And let's say they're even the most responsible kids in the world, but so it's not responsibility necessarily, but other things. Well, a lot of times when we're talking about long-term care planning, one of the first things that we, try to address for somebody is whether or not, control or maintaining control is a big issue. I mean, one thing, I'm sure if you've ever read anything about, aging and all of that, one of the biggest concerns people run into, understandably, is a loss of control or a loss of independence. And, driving is a perfect example of that. That's a big kind of breaking point for people a lot of times. But so maintaining control is important and maintaining independence. The concern I have with just transferring ownership over to someone else is that's the biggest loss of control someone could possibly have, right? They no longer own that asset. So if you gift your home over to your kids, and in this example, I'll say they aren't the best of kids and they're not responsible. This is where you hear the story sometimes of, well, my son started to try to charge me rent for my own home, or, wanted to sell the property and evicted me because I wasn't paying rent. And that sounds awful. And it morally is, but from a legal standpoint, once you've transferred ownership over to somebody, they are able to do those things. I mean, legally, obviously playing with landlord tenant law and all of that, but if as long as they're following the rules there, they are able to evict somebody, they are able to sell the property, even if it was your home that you transferred over to them. So that's a big loss of control. Now, assuming your kids are nicer to you than that, and you don't have that concern, that's not the issue, but it is a big loss of control nonetheless. So another thing with transferring ownership over to somebody when people don't do any planning, additional planning around it, is a lot of times I'll ask the client or the parent of the kids, hey, are you still paying property taxes? Who's paying the property taxes on that property? And they'll say, usually, well, me, it's my home. But from a legal standpoint, they don't own it anymore. So by paying those property taxes without an additional agreement, even if they made it out the 5 years from the transfer of that property, Medicaid again in that 5-year look back is going to look at somebody and say, why were you paying someone else's property taxes? So that again is a gift that would be, even though it's not intended to be a gift, it's a gift nonetheless from a legal standpoint. So you need to be very careful when you're gifting things over, even if everything else goes according to plan, because that can be an issue if it's not planned ahead. So that's really just more of some practical things that can go wrong even when all else is going well. But there are other things, speaking of taxes, that are a big concern when people gift over property, in particular real estate. So if you're familiar with the idea of capital gains tax, real estate, if you sell real estate and you have a gain on it, it's a capital gain. So you may have to pay capital gains on the gain from what you bought it for. Essentially, with any sort of depreciation adjustments, all of that can be more complicated, but it's essentially what you paid for it is your cost basis. And then what you sell it for is the difference between that is the gain. Now, with your primary residence, if you and your spouse still live in the home and you've lived there for 2 of the last 5 years, you get for each resident of the home that it's their primary residence, if they're the owner, they get a $250,000 exclusion of capital gains. So what that means is a married couple could have a gain of 500,000 and not pay capital gains tax on it. When you gift real estate over to somebody, in a lot of cases, the kids don't live in the home anymore. They're adults at this point, they're out on their own. So when that's the case, when they are gifted that property, they don't get that property. Their cost basis is not the fair market value. It's whatever yours was when you transferred it over. So let's say a family built their home in the 60s and it was worth like 30,000, or they spent $30,000 or $40,000 to build it. Well, that may be their cost basis in it or less. And now it's worth that to the kids. So when they sell it, because it's not their primary residence, they do not get that exclusion from capital gains. So even if it's after you pass away, if it was transferred to them before then, before you passed away, and it wasn't transferred through your estate plan, that would be a capital gains issue for them. And it happens a lot just because people aren't thinking about it. They're more concerned about just getting it out of their name, or maybe they didn't get advice on it when that transfer occurred, or didn't get good advice on it when that transfer occurred. That's entirely possible too. So capital gains can be a really big issue with real estate. You want to be very careful about how you are transferring things over. There may be better ways to do it. So when you pass on that real estate, though, as part of your estate plan, so whether you have a will or a trust, if it's part of your taxable estate, when you pass on real estate, or stocks for that matter too, they get adjusted to fair market value. That cost basis goes up or down compared to where the fair market value is. So what that means is once the kids inherit the property and then they sell it, they don't have necessarily, if they sell it relatively quickly anyway, they don't have that taxable gain issue or it's not as likely as it would be had they just been gifted it. Because again, it gets adjusted to fair market value, but if they hold on to it for a while and it grows more, they may still have capital gains issues. But if they sell it relatively quickly, there's not going to be, almost ever any capital gains, assuming they actually inherited it through your estate plan, if it was part of your estate. So that's where the gifting of that, though, for tax purposes, is not a really tax efficient way of transferring that asset, especially when there's better ways of doing it. It may leave that inheritance for them, but they're also going to then spend about 15 to 20% of their inheritance from that asset on taxes because of the sale of that property. So taxes are a big issue when we're talking about gifting, and especially gifting assets with cost basis associated with them. You gift cash over, there's not that same concern because it's just cash. There's no gain or loss with cash. It just is. It is what it is. It's cash, right? So that's a little different. But again, the gifting can still be an issue for long-term care. The third and probably most concerning thing that can go wrong with real estate, especially, or any asset really, but primarily real estate, would be if somebody were to transfer their home over to their kids to protect things from long-term care, but then something in those kids' lives happens where they have a liability come up. So I'll give you a kind of based on a real world example of why that's an issue. So in this example, the individuals or the couple gifted over their home to their 4 kids, 25 years ago, or before the family ever came in to talk to us. But in the intervening, 25 years or so, or maybe 20 years, some amount of decades anyway, they, never ended up needing long-term care. But even if they had been past the 5 years, right? That wasn't the issue. But they passed it over to the kids, and in the intervening years, 2 of the 4 kids passed away, which meant that each of those quarters went by the terms of that individual child's estate plan. So if they had a will or a trust, that's what happened with that estate. So one of the 4 that passed away was married, so it went to a son-in-law, and that wasn't an issue. I mean, he wasn't gonna evict mom or dad or anything like that. He was a nice enough guy. The issue came into play, though, where when the second child passed away, they were a single parent, went down to a grandchild. So that grandchild now owned a quarter of the property. The grandchild was like 5 when they initially did that transfer. So they didn't think about this going forward. But in the intervening 20 years, and by the time it came time to actually sell the home, that grandchild had a pretty bad substance abuse issue, which the reason the family came to talk to us was, how do we stop this grandson from using the money? To fuel a substance abuse issue or to fuel his addiction. And the problem with that is he owns the property, he owns his share of the property, and there's no way to stop him from getting access to it. So when we're talking about things happening to the owners of the home, it's not just Medicaid that I'm worried about. If you pass assets on to, or you transfer assets through gifting over to kids, what happens if they get sued or divorced or file for bankruptcy, right? Those things happen to the property that they own. You get some exemptions for like a bankruptcy with your primary residence if you're actually using it as your primary residence, but even then it's not incredibly large. But your kids don't get that if it's not their primary residence. So it's no different than if you own like a vacation property in the eyes of the court for the bankruptcy. So don't expect that while you're protecting it maybe from your care, that you're protecting it from everything, because it is an issue potentially for other people. There are examples of people getting divorced and it's a marital asset, and maybe it's a particularly contentious divorce, and they're not willing to give up that asset, or the value of it anyway, and it can create an issue there. So you don't want, if you're still living in the home, you don't want those things to happen to your home just because you're no longer the owner. There's actually more protection for you over your own ownership in terms of those sorts of things than if you were to gift it to a bunch of different people. You also look at it from sort of the standpoint of just how much liability is there. And in particular, when you're looking at long-term care, you may be looking at your own liability of care or you and your spouse's liability of care. In the example I gave, where there's 4 people involved, they actually doubled the points of contact on it, right? There's now more people involved and more people with liabilities potentially. So, it's just not the safest way to go about things. So this occurs, with a lot of different assets. We use the home as an example here because it's a pretty big one that most people try to protect this way. And unfortunately, there's a lot of advice out there about how easy this is to do, or, that'll work, just go ahead and do it, by people who maybe shouldn't be giving that advice, or just what somebody read online. There's another, couple of things too that I want to talk about with things that are still being done to this day that don't really work as well as people think they do. So a really common thing that used to be done a lot was what's called a life estate deed. So a life estate deed, you have the right to reside in the property still, but as you get older, it's based off of a life expectancy table. Your kids, or whoever is the remainderman, they call it, slowly gets more and more interest of ownership while you get older, and you get less and less. That used to be done to get things, out of Medicaid availability, and they used to not be recoverable by what's called a state recovery. If they were done prior to August 1st of 2014, they were not recoverable by a state recovery, which, think of that as Medicaid comes in as a creditor to the estate. So they get back what they paid, is what the way I look at it. So it used to be exempt from that. However, if they were done or after August 1st of 2014, they are still subject now to a state recovery. So, I've seen in the last year or last 6 months, a couple different life estate deeds that were done in 2016 or 2017 or 2018. And while that may not make that home available for care during that person's lifetime, it does not protect it from a state recovery. And so if that's the advice that person was given, it's either they were given incorrect advice, or the person just didn't know to give that advice, right? So if you have a life estate deed right now, you want to look at the date on there to see when it was done. If it was done prior to August 1st of 2014, they're grandfathered in. There are other potential tax issues with it, and potential ownership issues with it, but it's not, for the estate recovery side of it, as much of a concern. Now, if it was done after that fact, you want to catch it while you can, because there's ways that you can still protect things from that estate recovery. So what we do to kind of all of those concerns that I addressed, like the tax liability, the capital gains issues, the loss of control, the liabilities of the other new owners, right? All of those things, estate recovery, all of those things can be dealt with in a, at least in our view, a much more efficient and protected manner than, gifting the home over to the kids or using a life estate deed. So what we do with that more commonly, than any other type of planning would be using what's called an irrevocable trust. So irrevocable trust, it is a transfer of ownership. So it still counts as that divestment for care. You still want to try to do this 3 to 5 years before you need care, right? To try to get around the 5-year look back period. So you just never have to report it. The difference between an irrevocable trust and just transferring the home over to the kids, though, is how it works and what it protects. With an irrevocable trust, you're always going to have what's called an occupancy agreement, or you should have an occupancy agreement drafted for the home. So what that says is, with an irrevocable trust, you can't be your own trustee for Medicaid. So maybe it is still the kids, but in exchange for you continuing to pay the property taxes, the utility bills, all of those things that would be a gift if you didn't have an agreement in place, this agreement says in exchange for you doing that, they can't evict you or charge you rent or you sell the property without your permission. So that fixes that divestment issue of paying those property taxes, because you have something, you're given something in exchange for it now for fair market value. And it also protects the individual from being concerned about being evicted or charged rent to live in their own property. They don't own the property, the trust does, but the kids don't own the property either. They may just be the trustees of it, which is more like a property manager than an owner. With the tax concerns, most irrevocable trusts are, for this purpose anyway, are drafted so that they are included in your estate, taxable estate. What that means is not that it's taxed, it just means that, if you had more than $12 million in it, you may pay taxes on it. But for most people, that's not an issue, so especially when we're talking about long-term care. So with the irrevocable trust, when you pass away, if the home or any other capital asset goes through it, you then get that adjustment in cost basis when you pass away to your kids. So they then inherit it at fair market value cost basis. So it helps resolve a lot of those tax issues. And then, of course, with the concern about what happens to an owner of a property, then happens to that property as well, from liability standpoint. With that irrevocable trust, it is much safer than just putting it in the kids' names. The reason for that is, as I said, let's say, for example, you have 2 kids and you would have put it in both of their names. Well, if they're both the trustees, they're still managing it. They're still, the ones, working on the trust and making sure that things, things are working for you, which is no different in that sense than if you gifted it over to them. Right? That's the whole goal. The irrevocable trust still gets it out of your name for Medicaid purposes. But the benefit of that irrevocable trust is because they don't own the property yet. They're just the trustees. The trust itself is a separate owner. Their liabilities as trustees don't actually attach to that property, right? So if they get sued for some reason, they don't own your home. They don't own the trust does. They don't own it as trustees. So their liabilities are not going to be a risk for your home. Divorce wouldn't matter for that, right? They don't own the property. Bankruptcy wouldn't matter. If they pass away, it's not part of their estate. So you're not worried about that, issue with like a grandson, for example, with a substance abuse issue. So it protects against a lot of that. The other benefit too, with you setting up your own estate plan and using your own, like irrevocable trust to accomplish this asset protection, you're instead, that document should have provisions in there that say things like, hey, if somebody does inherit from me and they do have a substance abuse issue, or they are, just maybe not very responsible, or they have some sort of means tested assistance that they're getting, like Medicaid, for example, the way they inherit can be set up in such a way through your irrevocable trust, for example, that would not cause that issue. It would be protected for them or protected from those liabilities. So it's very important to have that planning in there, because you just don't know, right? You can sort of do the gifting over to the kids and cross your fingers and hope that that never happens, but that's not really good planning. That's more like burying your head in the sand a little bit, because you just don't know when things can go wrong. with irrevocable trust, those provisions are in there if they're drafted, properly, so that they do protect against those things, even if you don't know that they are a potential issue. Especially for people who are very young, and by the time they inherit, maybe much older, right? You just don't know. A lot can happen. So, when we're talking about that kind of thing with gifting it over or transferring things over to the kids, there's proper ways to do it without causing all those issues of like, hey, what about their liabilities or the tax issues, right? So you just need to make sure that you're talking with somebody, who does, practices pretty exclusively in elder law or estate planning, who knows how to plan around those programs so that they give you proper advice on it. I unfortunately have seen some examples of non-attorneys, quote unquote, doing long-term care planning, and they clearly don't know what they're doing. And unfortunately, things have gone wrong because of it. And there's sometimes it's too late to fix. So knowing that you're getting proper advice is very important. And just a reminder too, I'm not seeing any questions, but again, we do have a couple minutes left here. So if somebody does have any questions, please feel free to submit those. I guess for the most part, that's kind of most of what I wanted to cover today, but just a couple quick reminders before I let you go enjoy the hopefully still sunny day outside. Our topic next week is actually, our Wills versus Trust public seminar in Appleton at the Bordini Center with Fox Valley Tech. So that is we have 2 sessions at 2 p.m. and one at 6 p.m. So please sign up in advance, because I know if you're willing to attend and looking to attend, because seating is limited, the facility is still limiting seating. So just be very aware of that. So sign up in advance if it's something you're interested in. And then again, you'll be getting some feedback forms from us via email, and this kind of diagram of the home that talks about pretty much everything I talked about today in a more succinct manner than I talked about it. You'll get that feedback form, and if what we talked about today raised concerns for you, or you want to talk to one of our attorneys about any of those concerns that were addressed, please sign up for an initial consultation. Again, they are complimentary, and we schedule them for about 2 hours. So we can generally give you a pretty good idea of what we might need to do or what we would recommend by the end of that 2 hours. So if it's something that you feel you need to have addressed, absolutely reach out to set something up. Otherwise, again, if you're interested in the public seminar, it's going to be our Wills versus Trust seminar. So that gives you a pretty basic or a kind of general overview of wills versus trusts and the types of things that you need to be aware of in general for estate planning. So a little more broad than our topic today, but we do talk about this as well. So please sign up for that if you're interested. And otherwise, I hope you guys have a good rest of your day, and I will see you next.